Subscribe now and press the bell icon. Never miss an update.
Ready? 5 seconds. But at the same time, due regard has to be given to the qualifications required by the agreement and other considerations, and further in Union of India versus Singh Builders Syndicate, it was held as under the question that arises for consideration in this appeal by special leave is whether the appointment of a retired judge of the High Court as sole arbitrator should be set aside and an arbitral tribunal should again be constituted in the manner provided in terms of Clause 64, dealing with the matter arising from the old Act, the Arbitration Act 1940. This court in Union of India versus MP Gupta 2004 10 SCC 504 held that appointment of a retired judge as sole arbitrator, contrary to Clause 64, which requiring serving gazetted railway officers being appointed, was impermissible. The position after the new Act came into force is different, as explained by this court in Northern Railway Administration, Ministry of Railway versus Patel Engineering Company Limited 2008 10 SCC 240. This court held that the appointment of arbitrators named in the arbitration agreement is not mandatory or a must, but the emphasis should be on the terms of the arbitration agreement being adhered to and or given effect as closely as possible. It was further held in Northern Railway case 2008 10 SCC 240 that the Chief Justice or his designate should first ensure that the remedies provided under the arbitration agreement are exhausted, but at the same time also ensure that the twin requirements of subsection 8 of section 11 of the Act are kept in view. This would mean that invariably the court should first appoint the arbitrators in the manner provided for in the arbitration agreement, but where the independence and impartiality of the arbitrators appointed, nominated in terms of the arbitration agreement is in doubt, or where the arbitral tribunal appointed in the manner provided in the arbitration agreement has not functioned and it becomes necessary to make fresh appointment, the Chief Justice or his designate is not powerless to make appropriate alternative arrangements to give effect to the provision for arbitration. This court has put emphasis to act on the agreed terms and to first resort to the procedure as prescribed and open for the parties to the agreement to settle differences, disputes arising under the terms of the contract through appointment of a designate arbitrator. Although the name in the arbitration agreement is not mandatory or must, but emphasis should always be on the terms of the arbitration agreement to be adhered to or given effect as early as possible. It is in the present batch of appeals, independence and impartiality of the arbitrator has never been doubted, but where the impartiality of the arbitrator in terms of the arbitration agreement is in doubt, or where the arbitral tribunal appointed in terms of the arbitration agreement has not functioned or has failed to conclude the proceedings or to pass an award without assigning any reason, and it became necessary to make a fresh appointment, Chief Justice or his designate, in the given circumstances, after assigning cogent reasons in appropriate cases, may resort to an alternative arrangement to give effect to the appointment of independent arbitrator under section 11(6) of the Act. In North Eastern Railway and others versus Triple Engineering Works, though the panel of arbitrators as per clause 64(3) A, 2 and 3 of the General Conditions of Contract under GCC was appointed in the year 1996, put for 2 decades, the arbitrator failed to pass the award and no explanation came forward. In the given situation, this court observed that general conditions of the contract do not prescribe any specific qualification of the arbitrators to be appointed under the agreement except that they should be railway officers. Further, held that even if the arbitration agreement was to specifically provide for any particular qualifications of an arbitrator, the same would not denude the power of the court acting under section 11(6) to depart therefrom, and accordingly confirmed the appointment of an independent arbitrator appointed by the High Court in exercise of section 11(6) of the Act 1996. Almost the same situation was examined by this court in Union of India and others versus Uttar Pradesh State Bridge Corporation Limited, and after placing reliance on North Eastern Railway and others versus Triple Engineering Works, held that since arbitral tribunal has failed to perform and to conclude the proceedings, appointed an independent arbitrator in exercise of power under section 11(6) of the Act 1996. In the given circumstances, it was the duty of the High Court to first resort to the mechanism in appointment of an arbitrator as per the terms of contract as agreed by the parties, and the default procedure was open to be resorted to if the arbitrator appointed in terms of the agreement failed to discharge its obligations or to arbitrate the dispute, which was not the case set up by either of the parties.
Subscribe now and press the bell icon. Never miss an update.